Hi, everyone. Welcome to the Bienvenidos Todos webinar with ECMV and the Virginia Board for People with Disabilities. We are excited for today's webinar and really want to thank the Legal Aid Justice Center for being such a major partner with us in getting people and Latinos, people with disabilities and Latinos, organizations that are serving them and families that need the information regarding special education and our rights. I am going to read our disclaimer. Again, we want to thank the Virginia Board for People with Disabilities for making this possible. Bienvenidos Todos project is a very important statewide project for Latinos with disabilities, their families, providers, and all our families across the state. Our organizers and our team has been working hard in ensuring these webinars are very up to date and the information needed for our people with disabilities. Please check out our landing page that is going to include this presentation on all previous webinars, and also will include fact sheets. The fact sheets will have resources where anyone that needs to access the information can have the information and links to resources that pertain to the organization and the topic. I am very happy to present Legal Aid Justice Center today as a partner in this presentation. We have Amber Banks here today, who will be giving us information on special education rights under IDEA, Individuals with Disability Education Act. Thank you so much. I'm going to stop sharing my screen and allow Ms. Amber, who is joining us today, to take over. Thank you so much, Amber, for being here with us.
Thank you. I'm so glad to be here with you all. Let me get this going. So my name is Amber Banks. I am an attorney at the Legal Aid Justice Center, and I specifically work on education issues and representing families with education matters. And so today, I'm going to talk to you all a little bit about disability, language access, and immigration rights in education. This is a lot, and each of these could be their own presentation. So I am going to try and make sure that I leave a lot of time for questions so that we can focus on the things that you are most interested in or the things that you want to know more about. And our disclaimer is the Legal Aid Justice Center provides free legal services to low-income individuals on an array of issues, including education matters, and defends the interests of low-income communities. The Legal Aid Justice Center.
I'm sorry to interrupt. Can you just give me 1 second?
Sure.
I have to get my interpreter back in, and
She's in. I can see her.
there we are.
7.
Okay. Sorry, Amber.
No problem. So the Legal Aid Justice Center does not represent government agencies or nonprofits. And the information in this presentation is for educational purposes only. It's not legal advice, and it does not create an attorney-client relationship between you and us. If you have, if you're seeking legal advice, you should consult an attorney. And so I just have to make sure you all know this is information, and as you may be aware, a lot of things change really quickly, especially when we're talking about schools and immigration issues. And so this information is, to the best of my knowledge, correct today, but you should always double check before relying on any information or talk to an attorney if you need legal advice. And so my plan for today is to give you all a little overview of education laws and the right to education, both at the federal and state level, and then specifically talk about language access rights and the rights of English learners at school, rights with respect to immigration and immigrants at school, rights under IDEA and other disability laws, and then have time for you all to ask questions and get more information about whatever you're most interested in. I think I told you a little bit about who we are as an organization, and I'm specifically part of the Youth Justice Program that works with youth and families and communities. So I'm going to start with an education law overview. At the federal level, we have Title VI of the Civil Rights Act of 1964. This is a federal law that prohibits discrimination on the basis of race, color, or national origin in programs and activities that receive money from the federal government. And we will talk about this more, but national origin is usually where we talk about language access also coming into play. There's also the Equal Educational Opportunities Act of 1974. This prohibits discrimination against faculty, staff, and students on the basis of race, color, gender, or national origin, including racial segregation, and requires school districts to take action to overcome barriers to students' equal participation. At the Supreme Court, there's been a lot of cases related to education, and I pulled out, I think, 3 of the most important ones for what we're going to talk about today. San Antonio versus Rodriguez, the Supreme Court said that there's no constitutional right to an equal education. So I think that's important to know going in, that at the federal level, there's no right to an equal education for all students. However, we do have 2 cases, one from 1974 and one from 1982, that broaden education rights. And so the first one, Lau versus Nichols, the court said that there has to be language instruction in public schools for students who have limited English proficiency. That's based on the Civil Rights Act of 1964. And in Plyler versus Doe, the Supreme Court said that under the Constitution, the US Constitution, states have to offer a free public education to undocumented school-age children on the same terms as it offers to US citizens or to legally admitted aliens. At the state level, we also have a pretty strong educational protection. The Virginia Constitution affirmatively says that the state has to provide a system of free public elementary and secondary schools for all children of school age throughout the Commonwealth. And as you can see here, the Virginia Code defines children of school age without any mention of national origin, language ability, immigration status, disability or not disability, race, gender, anything like that. So this is just solely based on their age and their living in Virginia. There are also a number of federal disability laws. The biggest ones that we rely on are the Individuals with Disabilities in Education Act, IDEA or IDEA, Section 504 of the Rehabilitation Act, and the Americans with Disability Act. So all 3 of these cover schools in different ways and sometimes overlapping ways. Let me just make sure that there's no questions. Okay. So let's talk about language access. I'm going to start by talking about parents, and then we'll move on to students. So for parents, if parents are what we call LEPs, limited English proficient, or English learners, they're entitled to meaningful communication from their children's schools in a language they can understand. And this generally means their native language or the language that they primarily use at home. And I think it's important to point out that this doesn't mean that if they speak some English, they aren't entitled to any interpretation or any communication in their primary language, because plenty of people speak some of a different language, but aren't able to have a meaningful or full conversation in that language. And so the definition we look at is their native language or the language they primarily use at home. In line with this, schools also should offer translated documents and letters and use a language interpreter in meetings. And that is to be provided to the parents at no cost to them. And those the interpretation needs to be done by appropriate, competent individuals. So it can't just be they pull a random person who happens to be bilingual or even have like the person's children be interpreting for them. It should actually be an interpreter. And I am, of course, very glad to see that there are interpreters, ASL interpreters on this call, and that's important that we actually have competent interpreters provided to families. The other thing that's important is that parents who do not speak fluent English or that speak limited English or that are English learners have to be given notice about any program, service, or activity that concerns all students. And so I put some examples here. So that includes registration and enrollment in school and in other school programs like clubs and extracurriculars, report cards, gifted and talented, school discipline, parent-teacher conferences, special education, getting permission to go on field trips or participate in school activities. It's really, the important thing here is, right, making sure that there's an equal access to education for the students. So they should have access to everything that other students have. And in cases where a lot of times that's going to rely on parents knowing what is happening or giving permission for things, their parents need to be aware of this information in a way that they can understand. Now, when we talk about the students, all school districts have to have a procedure to identify students who are potentially English learners. And that's usually done by a survey, a lot of times a home language survey at the beginning of the year, but there's different ways they can do it. If a child is identified as a student who's an English learner, the school needs to notify their parents, and the notification has to include information about the child's English proficiency level, as well as programs and services that are available to meet the child's needs. When a student has been identified as an English learner, they're entitled to language assistance that is necessary to help them become proficient in English and necessary for them to participate equally in the general education curriculum within a reasonable period of time. This is not a specific thing. There's not like within X number of years or months they have to be fully fluent. Certainly that can depend a lot on the age of the child or how much English instruction or exposure they've already had or other things like that. But it does have to be a reasonable period of time. And these students are supposed to be taught appropriate grade level curricula so that they can meet promotion, that's like going up in a grade, and graduation requirements. So it's important that students are on track to graduate no matter what language they speak, and that the school is giving them the assistance they need. And like I mentioned before, this English learning students have to have an equal opportunity to participate in all school programs, whether that's pre-kindergarten, magnet schools, gifted and talented, advanced placement, art, athletics, anything. And it's important that they have access to all of this and not just to a few things that someone assumes students who are not fluent in English are interested in. Another state law I want to highlight is that Virginia has a law that says that students who enter Virginia public schools for the first time at age 12 or older and are identified as English language learners may remain in school until age 22. So what we have here is, this is based on each school board, but generally a lot of schools have this. And the idea is that if a child is entering the school system for the first time and they're 12 or older and they are not already speaking English, it might take them a little bit of extra time to catch up and learn English and meet all the graduation requirements. And so that's provided, this law provides them extra time to do that. I don't know whether, I guess I'll just continue because it's hard for me to pull up the Q&A at the same time, and then I'll do all the Q&A at the end, but feel free to interrupt if there's something really important I need to clarify before that. So the second thing that I wanted to talk about is immigration law and the rights of immigrants, students, and parents with respect to education. So I'm going to start with students from other countries. Schools cannot deny a free public education to undocumented school-age children that live in the school district because of their citizenship or lack thereof. Schools are not even supposed to inquire into citizenship, visa status, immigration status of this child or their parents.
Amber, we might have to take a quick pause. We are just switching interpreters.
Absolutely.
This is the other interpreter. I just need to be spotlit.
Okay, could you let
Can
us
you
know?
pin and unpin me?
Let me co-host. I can co-host. For that person. I
And the
co-host.
other person.
And in the chat, they're saying if you could just make both interpreters co-host, then we can spotlight ourselves.
Both are co-host.
Okay, both are co-hosts now.
I got you, Jay.
Okay, perfect.
Thank you so much. It's my first time doing all this. Amber, we're ready to go. Thank you.
All right. So with respect to students from other countries, schools cannot deny a free public education to students because they're undocumented or because they are not citizens or because of anything to do with their visa or immigration status. If a child of school age lives within the school's jurisdiction, they are eligible for free public school. And schools should not even be asking students or parents about their immigration, visa, or citizenship status as part of the process for enrolling in school. Schools also can't refuse to enroll a student because they have a birth certificate that's from a different country. They also cannot refuse to enroll a student because they have no birth certificate. There are some other ways that students can prove that they are of school age in that case. One exception to the school age rule is that if a student is transferring from a school in another state or another country and they already have a comparable diploma, then they might no longer be entitled to an free public education because they've already got a diploma. But unless that student already has a diploma and it's comparable to the diploma they would get in Virginia, if they're school age and they're living in the district, they're entitled to enroll in school. There are also some special circumstances that give students access to free public education in Virginia past the age of the school age. And one of those is special education. So this applies to students from other countries and students who were born in or live in or are citizens of this country. All special education students, if they need to, can receive special education and related services through age 21, unless they've graduated with a comparable diploma. So special education students are eligible to have extra years of free public education if they need it. And like I mentioned earlier, Virginia also has this law for English learners who enter the Virginia school system for the first time at the age of 12 or older, which gives them up to the age of 22 to receive their high school diploma. And so I think the important takeaways here is that all students in kindergarten through 12th grade can go to their local public school for free, no matter where they were born or what their immigration status is. It includes students who are immigrants, refugees, undocumented, kids who do not speak English. And the flip side of that is kids who are of school age have to attend school. If they don't attend school, they might get in trouble for truancy and their parents can face legal consequences. So I think it's important to note that both if they don't have a high school diploma or a GED in their school age, they are entitled to a free public school and they have to attend school. They don't have to attend a public school. There's also options for private schools or home instruction, like homeschooling, that have different legal regulations, but they have to have some sort of education when they're school age, or unless they already have a diploma or a GED. When it comes to enrollment, schools cannot require a social security number to enroll in school. They also cannot require a US birth certificate. So like I mentioned earlier, they often ask for a birth certificate to prove age because, again, we're looking at what is a child of school age and if they're eligible. But if the student does not have a birth certificate, there's other ways to prove their age so they can still go to school. And it's important that schools should not be asking about or keeping records about a student's or parent's immigration status. That's not relevant to whether they can enroll in school or their education, right? So whether they are limited English proficient, whether they're English learners, that is relevant to their education, but what their immigration status is not relevant. Now, children have to attend the school that their home address is assigned to. That's their attendance zone. There are some ways around this. Some school systems have lotteries or different systems where you can apply to transfer to a different school. But generally, the student has to attend the school that their home address is zoned to. And schools can and do require proof of address to enroll a child in school. It's also a crime to use a different address to enroll a child in a different school or school district. And adults can both be charged with a crime and forced to pay tuition to the school that their child attends if they have lied about the child's home address. And I think it's really important for people to know this. It can be especially difficult for newcomers to understand, like, what is my school? How do I even know which school is the right school to enroll in? And for anyone who's moving around frequently, whether it's because of poverty or other reasons for housing instability, it might be difficult to remember to update the school about their address, but we really want to make sure that no parents are getting in trouble for having their child enrolled in the wrong school and that kids are getting the free education from their local public school in a way that doesn't put their families at risk. There is another federal law that I did not mention earlier called the McKinney-Vento Act. And I think this one can be really useful for a lot of students, both immigrant students and students who are low income or who are facing housing instability, and students who experience disasters, natural disasters or fires or anything like that. So McKinney-Vento Act gives special education rights and extra services from the school to any child who's considered homeless. And homelessness under McKinney-Vento is a lot broader than how we tend to think of homelessness. It can include living on the street or living in a car or living in a homeless shelter. It can also include living in a hotel or a motel or a campground because you can't afford anything else. It can include couch surfing, living doubled up with multiple families living together because they can't afford separate housing. And if a student is homeless, they qualify for services through McKinney-Vento, even if they live with their parents. But this can also help students whose parents are taken away from them, either temporarily or permanently. For example, if a parent is detained, arrested, or deported, or a parent is long-term hospitalized, is sick and is in the hospital for a long time, the student might qualify for free help from the school under the McKinney-Vento Act. And the big thing to think about here is whether it is a planned or unplanned circumstance. So if someone's parent is arrested and their best friend says, okay, well, parents say, come live with us for a while till we figure out what's going on, that is an unplanned and temporary situation, and that student would probably qualify as homeless under the McKinney-Vento Act. But say a parent knows they're going to be going into surgery and be recovering in the hospital for months. They know they're going to be deported. They know they're going to be incarcerated for a number of years, and they set up a permanent or like long-term situation for the child, for someone else to care for them. That would not be considered a situation where the child is considered homeless and qualifies for McKinney-Vento. Every school district has a McKinney-Vento liaison, and their job is to find the students who qualify under this law and make sure they get help. These students can start school right away without the usual paperwork. So if they don't have proof of address or proof of their vaccines or their birth certificate or anything, they can still start school right away. And then the school helps them get that paperwork and that documentation. Under McKinney-Vento, the children also get access to other things they need in order to access their education. So this could include free transportation to their school. It could include books, school meals, uniforms. It could include tutoring or other programs to help them like graduate or with college counseling. And it's a really important service, I think, that a lot of students can benefit from. And so I think it's really important that if you think you might qualify, or if you know a student who you think might qualify for this, that you talk to the McKinney-Vento liaison. That person's job is to figure out whether someone qualifies under the law. So you don't have to figure out yourself whether you meet the definition. And there's also something called Project Hope, which is the statewide group that kind of manages the McKinney-Vento program. They have a list on their website that I've linked here of every liaison so that you can find the one for your school district. They also have information and can answer questions if you have questions, and they handle any appeals. So say you think you qualify, the district's liaison says you don't, you can appeal to Project Hope, and they're the ones who will review that. Another important federal right is the right to privacy. So there's a law called FERPA, the Family Educational Rights and Privacy Act. This law protects the privacy of all students. So it includes immigrant and undocumented students, students with disabilities, students regardless of English ability. All students are protected by FERPA. And what this means is that schools cannot share the personal information about a student without the written permission from their parent or guardian. When the student becomes an adult and turns 18, becomes an adult, that right transfers to the student to give written permission and is taken away from the parent. Personal information includes things like race, nationality, gender, social security number, if the school has it, the place of birth, their citizenship, anything like that that the school has. There's also information called directory information, and this information is treated differently under FERPA. The assumption is that schools can share directory information unless the parent asks them to keep it private. And directory information can include like the student's name and address, phone number, if they're enrolled, what grade they're in, any awards they're getting. These kind of things are able to be disclosed without permission, unless the parent says, I want this private, or when the student becomes an adult, again, they are the one who does that. So every year, parents can contact the school and say they want their child's directory information to remain private, and then it won't be something they can disclose. But when it comes to personal information, it's not going to be disclosed unless the parent gives permission. There are a few exceptions to FERPA. One of the exceptions is that school police officers and school law enforcement their records are not protected by FERPA. So we're talking about school security officers or other names they might have, school resource officers who are employed by a law enforcement agency and then assigned to the school. So they might work for the sheriff's department and their assignment is to work in the school. Well, those are not considered school records, right? Those are considered law enforcement records. So anything that the school police officer knows is not protected by FERPA. And that's just one thing that is important to know. There's one exception in FERPA for international students that can confuse some people, but that has nothing to do with undocumented students or DACA students or anything like that. The other big exception to when schools can and in fact have to share student records is if they get a court order or a legal subpoena. We'll talk more about subpoenas and court orders after this slide, but since it comes up again, I wanted to get through this one. A big question we've been getting recently is ICE at schools and where can they go? So it's important to know that ICE can enter public spaces without a warrant. A public space is a place that the public can generally enter. That might be outside the school, in the parking lot, in the lobby. If anyone in the community can walk into a space, that is generally a public space. It also can, and spaces can change whether they're public or private based on how they're being used at the time. So, places at school like the school gym might normally be a private space that only students and teachers can access. But when there's a basketball game, the public's allowed to come in. And then that would become a public space at the time in which the public is using it. This could be, there's a play that the school is putting on, there's sporting events, there's a bake sale, whatever it is. If there's something where the public is welcome to come in, that is a public space. But ICE cannot enter private spaces unless they either have a warrant or permission of the school administration. And so parts of the school that are not open to the public are private spaces. Most parts of schools are private spaces, right? We generally have a lot of security to make sure that folks can't just walk into schools unless they go to school there or they work there. And so if it's a place that requires identification or permission to enter, that's a private space. So hallways, lunchrooms, gyms, auditoriums, probably private unless, like I said earlier, it's an event that's open to the public. Whereas classrooms and employee offices or things like that are also almost certainly private unless there's some sort of public event going on. And what that means is that unless the school gives them permission to walk into these private areas, ICE would need to have a warrant. So I want to talk to you a little bit about subpoenas and warrants and what you need to know. Subpoena is like a special letter from the court that says you have to do something. You have to show up at court on X date, or you have to hand over certain records. That's a subpoena. And a warrant is similar, and what it does is it gives a person permission from the court to search a place, like a home, to search a person or their belongings, or to arrest a person. And when those are issued by a court, it's a rule that you have to follow. I have to follow. Everyone generally has to follow a court order. But not all subpoenas and warrants are the same. Unfortunately, government agencies also use their own version of subpoenas and warrants, and that can be really confusing for people. So a subpoena has to be signed by a judge in order to have power over you, unless you work for that agency. It can be confusing to figure out which is which, though. And I think I've tried to put this together to make it easier to understand what we're talking about. So the federal government, we're split into three branches: the legislative branch, the executive branch, and the judicial branch, right? We've got Congress, the president, we've got the courts. But agencies like ICE are actually under the executive branch. So even though ICE or Department of Homeland Security might have their own court and their own administrative judges, they're still under the executive branch and they're not under the judicial branch. When we talk about a warrant signed by a judge, we're talking about a warrant that was signed by a judge who's part of the judicial branch. And that is the kind of warrant or subpoena that you have to follow. Obviously, you can get a lawyer, you can go to court and try to say, no, judge, you should change your mind, but you have to follow it. If there's an administrative subpoena or an administrative warrant that's issued by the Department of Homeland Security, that does not have power over you. You do not work for them, and so you do not have to follow it. And I think sometimes law enforcement and ICE officers rely on people not really understanding the difference, knowing that they can ask for a warrant or subpoena and not really understanding that what they're being given is not a judicial warrant. So just so you can see here, if at the top of the document it says U.S. Department of Homeland Security, that's not a judicial warrant. That's an administrative warrant. And if the signature there is from an immigration officer or an immigration judge, that's not a judge when we talk about a judge who's part of the judiciary. But if a warrant says United States District Court, right, it's issued by a court of the state or the federal government, and it's signed by a judge who works for the judicial branch, that is the kind of warrant that you have to listen to. So if there's a subpoena or a warrant, that is something that could give ICE access to a private area in a school, and that is something that could compel the school to hand over educational records about a student. The last topic for today is disability law and rights in education. So the big one here is that we talk about is special education. Although I do want to acknowledge there are other disability laws that relate to teachers and visitors to the school having physical access if a disability might limit them. Special education is the big one that's impacting most of our students. And special education is a system of services and supports that are designed to meet the specific learning needs of a child with a disability. So that could be a physical accommodation, like where the child sits in the classroom. It could be testing accommodations. They might need extra time or they might need a private space. And it can also be behavioral. So they might need supports to help them learn social skills or help them manage behaviors related to a disability that are interfering with the school day. Special education can also include non-education services. So maybe the student needs a special type of transportation in order to get to and from school, or they need extra training or counseling related to their disability. And all of these services are designed for the individual child. There's not like one standard way to do it, and it's provided without cost to the family. There's a number of different categories that lead a child to be eligible for special education. I've put them up here, but these also can encompass things under them. So, if you don't see a specific diagnosis, that doesn't mean that it's not covered. It just means it might be under one of these. Now, the process for getting started in education. First, a child has to be identified as potentially having a disability. Second, there'll be an evaluation, and then there'll be a determination of eligibility. So what does this mean? First, if a parent or anyone else at the school thinks that a child might have a disability that's affecting their education, they can request an evaluation. The school does have to ask the parent's consent to evaluate a child, and the parents can refuse consent, although it's possible for the school to challenge this refusal. But it is, it's not something they can do just like without asking permission or easily by ignoring lack of permission. And after evaluations are done, a team of professionals looks at those evaluations, meets with the parents, and they talk about whether the child is eligible for special education services under IDEA. Or they might say this child is not eligible under IDEA, but is eligible for services under 504 or something different. So this is kind of a guideline for parents, but I think it's important for everyone to understand the process. First is requesting an evaluation from the school. And this, there's not like one way to do it. In general, we advise people to do it in writing and have a copy. Email can be a super easy way to do it and to explain why, like what you're seeing that you're concerned about, and say, I'd like my child to be evaluated for special education. Like I mentioned, a teacher or someone else at the school can also request an evaluation. The school, if the school wants to just says, yeah, that sounds about right, we're going to evaluate them, they will ask for permission from the parent and then do it. It's also possible the school will say, no, we don't think this child needs an evaluation. But they also have to give that information to a parent in writing and why they don't think the child needs an evaluation, and that parent can challenge that decision. If a student, and like I said, if a parent refuses to consent to evaluation, the school could file what's called a due process complaint and attempt to override your decision. This is a bigger process through the state and is something you'd be notified about. And it would be, there would be opportunities throughout that to have your point of view heard. But also, we would recommend that if someone has filed a due process complaint against you, you talk to an attorney to make sure you understand the process and all your rights. And so what are parents' rights in the evaluation phase? Parents have the right to tell the school what areas they think should be assessed. Special education and disabilities, that can be so broad that generally evaluations are going to be targeted at some of the issues that the parent or the teacher are seeing with this specific child. So if they're seeing an issue with the child's hearing, they're probably not going to evaluate whether they can walk. Maybe that's not the same thing. Or if they're seeing a behavioral issue, they might not be evaluating, whether they can see, right? Unless they are thinking that those are related or have a reason to believe that both things are happening. So parents have the right to say, these are the behaviors I see and what I think should be assessed. They can also say, we have a family history of this, or my doctor has said or diagnosed the child with this. Parents have a right to tell the school what kind of assessments they're looking for. Parents can also take someone with them to the eligibility meeting. It can be their friend. It can be someone who works with the child inside or outside of the school. It can be an advocate or an attorney. Parents don't have to go through this alone, especially if they know someone who either has expertise on special education process in general or has specific expertise about the child. Again, when we're talking about language access, parents have the right to be able to participate in these meetings, and that means that the school needs to provide an interpreter, right? And again, we're talking about the parent's native language or the language they primarily speak at home. Anyone who's gone through this process might know that it can be complicated, especially if you're new to it. And complicated things, I think, are best when you fully understand them, when there is a translator available, and not when someone who speaks some of a language but isn't fully fluent in it is expected to keep up with things that even those of us who are completely fluent can take a long time to understand. And parents also have the right to receive a written copy of the reports, of the evaluation reports. And in general, we tell parents to ask for these reports before the meeting, eligibility meeting, get it in writing, pick it up, and make sure they have time to review it before that meeting so that they can ask the questions at that meeting that they want to ask. And another important thing for evaluations, a child should be evaluated in the language with which the child is most comfortable and familiar. So what we don't want and what we have seen happen is a child who is classed as special education because they don't speak fluent English and they're assumed to have a learning disability or something like that. And on the flip side, we also don't want a child whose special education needs are ignored because it's assumed that they just need to become fluent in English. Once evaluations are done, the school has a meeting to determine if a child's eligible for special education. Parents are invited to be part of that meeting, and it's really important that they're there so they can talk about what their child's needs are. There is a timeline for how long schools have to complete the process. It can be extended if parents are not providing the access to the child in order for the evaluations or assessments to happen. At the eligibility meeting, parents have the right to participate. They have to know when the meeting date is. They have to be allowed to attend, and there will be a written summary that goes into the child's education records that the parents have access to. Again, school needs to provide an interpreter so that the parents can actually participate in this meeting and understand what's going on. Parents also have the right to refuse to medicate their child. So the school can't force parents to medicate the child as a condition of attending school or receiving special education services. Medication is a decision that parents make in consult with the doctor, not with the school. The school might suggest or ask if medication's been considered, but they cannot require it. Parents are also allowed to refuse and to sign at the eligibility meeting. If they disagree with the eligibility summary, they can say no. Maybe they disagree because the school has said this child's not eligible and they think their child is, or maybe they disagree because the eligibility summary has one diagnosis, but they think their child has 2 additional ones and they think it's not complete enough. Whatever it is, the parents are allowed to disagree with the school about the evaluation. And if they want, the parents can have the child reevaluated by someone outside the school system that's an independent evaluator. And the school pays for one of these. They do set some guidelines on how much they'll pay or things like that. And they will give a list often of who might do these evaluations, although parents are not bound by that list. Now, if a child is eligible for special education, there will be an IEP meeting. And an IEP meeting is when a team of professionals from the school, including special education teachers and general education teachers and other people who understand the evaluations that were done, meet with the parents, and they all work together to develop an individualized education plan. This plan is they say individualized because it's individual to that specific child and addresses their needs, goals, and services. When I say individualized, I mean there's not like, if a child has autism, they get this, this, and this, the end. It's about each child. It's not about each diagnosis. Parents can agree or disagree with the IEP and can request additional evaluations, as I mentioned. Parents have to consent to the child getting special education services. So they can say no if the school wants to do something that they think is not in the best interest of their child. And parents also get progress reports, and there are annual meetings to review and revise the IEP, and there'll be reevaluation regularly as needed. In addition to the annual meeting that has to happen, parents can request an IEP meeting outside of that time if they have a concern or they want to change to the IEP. Say the progress reports show that the child's not making progress, or they hear from their child that something's not working, they can ask for an additional meeting in order to discuss those concerns and ask for the IEP to be edited and changed. So an IEP specifies what services the child's getting, where the services are being provided to the child, when the services start, how long the services last, and how the child's progress is measured. It's a written commitment from the school about the services they are providing to the child. And so it's really important that anything that is discussed at the IEP meeting that parents think is important is in the written document. If it's not written down, then it is not part of the IEP. When we talk about an IEP for English learners, it's really important that the IEP also addresses the student's language-related needs. And it's really important that someone on the team is knowledgeable about the student's language needs. Like I said before, we don't want students who are English learners to have their special education needs neglected, and we don't want students who are English learners to have their English learning needs not met, because it's important that they're getting all of these services that they're entitled to. And it's important that that the IEP team understands their language needs, and so that can be addressed. That, like I said, the plan is individualized to the student, and so that if an individual student needs language to be part of their IEP, then that needs to be in there. Parents have the right to be invited to the IEP meeting, and the school needs to take reasonable steps to make sure they can attend. So the school needs to try and schedule it with the parents. It's possible if the parents are totally refusing to meet at any time after multiple options that they will say, we're just going to meet without them, but they really need to make an effort to include the parents in this meeting. And parents should try to attend because they are the best advocate often for their child. Parents can also bring someone to this meeting, including a friend, family member, an advocate, or a lawyer. Again, parents have the right to an interpreter so that they can actually understand what is happening in the meeting and have meaningful communication with the other members of the IEP team about the services and needs of the child. Parents also have a right to their child's school records, including the evaluations, drafts of the proposed IEP if there are drafts, and any assessment reports that they're entitled to get this before the meeting happens. And in terms of school records, actually all parents, even if they're not special education parents, are entitled to the children's school records. But when it comes to special education, there's the additional requirement that they get those records before the IEP meeting. And again, with the IEP, parents have the right to disagree with the school's proposed IEP, and they can refuse to sign saying they agree at the end of the IEP meeting. One last thing about students with disabilities is school discipline. School discipline can vary slightly for students with disabilities. So there's no difference when it comes to a short-term suspension, which is 10 days or fewer. A student with a disability can get the same suspension as a student without a disability. If a student with a disability gets a long-term suspension, which is more than 10 days, or expulsion, which is 1 calendar year, then that's considered a change in placement. And anytime there's a change in placement for a student who has an IEP, the IEP team has to be involved in that decision. Another thing to know is that a series of short-term suspensions that form a pattern and that add up to more than 10 days can also be a change in placement. So let's say the student gets multiple 2 or 3 day suspensions for the same issue over and over and over. When that goes over 10 days, that can also be considered a change in placement because it has, as a cumulative matter, gone over 10 days, and it's really the same thing happening over and over again. If there's a change in placement, for a student with a disability, the IEP team is going to convene first and decide whether they think that the disability caused or substantially contributed to the behavior that the student is being punished for, or whether the school's failure to follow the IEP contributed to this behavior. In most cases, if it was related to the student's disability or the school's failure to follow the IEP, the child can't be punished because it's considered being punished for conduct that's part of their disability. There are some exceptions for weapons, drugs, serious injury to another person, where the child might still receive some punishment, even if it is related to their disability. However, whether or not a child's behavior is related to their disability, if they are a child with an IEP, a child with a disability, they are still entitled to a free and appropriate public education. So even when they're suspended or expelled, the school still has to provide services so that they continue to meet their IEP goals and so that they're able to participate as much as possible in the education system. And just to wrap all these up together, the right to special education does not depend on the students or their parents' ability to speak English. English learners should be evaluated for special education in a language they understand. The IEP team for English learners should include someone who understands the child's language needs, and these needs should be included in the IEP. And meetings and communication with parents should be in a language that parents fully understand at no cost to parents so that they can fully participate. And the right to special education does not depend on the students or their parents' immigration, citizenship, or visa status. Students can't limit or refuse access to education or special education services based on immigration or citizenship status, and they shouldn't be asking about immigration or citizenship status at all. So I'm going to move on to questions, and maybe I will stop sharing so I can see what's in the chat. And if any of those are questions, or if you all want to raise hands and ask questions, whatever might be easier. But just so you have it, here is the information about our office locations and my contact information if you want to contact me directly. So I'll leave that up for 5 more seconds before I stop sharing and take a look at the chat. All right. Let's see. Chat. Okay. All right. I think I'm glancing through the chat now to see if there are any questions related to me or what I have shared. Does anyone have other questions? You can put them in the chat or in the Q&A if
I think
you.
someone had requested the slide deck
Sure.
to share with their team members, if that was
Mm.
possible.
That is
Right.
possible. And I'm gonna put my email address in the chat too. If you want the slide deck, you can just send me an email and I'm happy to send them to you.
And the presentation will be a part of our Bienvenidos Todos landing page on ECMV's website. So this presentation is recorded and will be on our ECMV landing page for Bienvenidos Todos with a fact sheet, making it, a little more, given more details, but also additional resources and links.
I also see a question about whether we have this information in other languages. We're going to be doing this presentation again this evening in Spanish. So we should have that there if you're interested in it in Spanish. If you're looking for it in other languages, we don't have that at the moment, but again, you can email me if there's something specific that you're looking for, and we'll see if we can help facilitate that in some way, because we're well aware that even though Spanish speakers are the biggest group of limited English proficient parents and English learner students in Virginia, they are not the only ones, and that others folks can benefit from this information.
I wanted to take the time to just thank you, Amber, for this really, really valuable information, and thank the Virginia Board of People with Disabilities for making this possible. And our amazing ASL interpreter, more than one interpreters, but making this possible and very accessible. And we're trying our best here, but we want everyone to be included and have the opportunity to really obtain this information. Your presentation was amazing, and we are just very, very grateful to have you be able to share this information with our families and our organizations, and anyone here who may have someone that has a disability in their family, Latino or not, but everyone should have access to this really important information. So Amber, again, thank you so much. And any additional questions can always be emailed in or info@ecmv.org. Also, Amber has put her information in the chat as well.
Thank you all so much for having me today. We're really grateful to everyone who tuned in, and I hope that you were able to learn something. And like I said, we're happy to share more resources if we're able to.
Thank you so much. We are also streaming live on Facebook and YouTube. So please share this presentation with anyone who you may think can really benefit from it. Again, thank you so much, Amber. Thank you so much, Ms. Cheryl, and all those that have supported this project. Rosalia Fajardo couldn't be here tonight. She's recently a grandma, but I just wanted to thank her and Ms. Sherry Takamoto, Jimena, all our organizers for making this possible. Thank you all. And again, if any questions, please reach out. And thank you. See you tonight in Spanish, 7 p.m.